So Judge, as you've indicated on the record, this is the time and place scheduled for a potential evidentiary hearing. When we were here originally on this matter, the petition that was before the court was for a protective order to basically try to restrain assets and to have Ms. Williamson appointed as the PR. I believe subsequent to that order, Mr. Maples filed an objection to that order. Subsequent to that, Judge, I did file another petition with the court. It's quite lengthy and I do apologize for the breadth, but the court did ask a couple of questions at the initial hearing that I did some research on, and I just wanted to be able to present it to the court so that the court had all of the information before it. And I guess I want to deal with those issues out of turn. One of the questions the court had was whether or not it needed to conduct an evidentiary hearing on this matter to make a determination whether there was a killing under the statute, specifically MCL 700.2803. And that, Judge, I actually briefed that issue second, but I've given the court the Mike's case as well as the Hadley opinion, both of which basically indicated that the court is not required to conduct an evidentiary hearing if it's not necessary. And in both cases, they relied on other information to basically make a finding by a mere preponderance of the evidence, which is the requirement under subsection 6, that there had been a killing in violation basically of the statute. And so both of those cases that basically came down and said that the court is not required to hold an evidentiary hearing in order to make that determination. And in some cases, they required death certificates or medical examinations and other documentation, which has been supplied to the various probate courts in making that determination. In this case, Judge, I've given you the police reports. They were long. There was about 56 pages of police reports filed by Officer Howard, who was here in the back of the room, as well as other officers, including Officer Burke from the Madison Township Police, who was here as well. In those police reports, Judge, there's various admissions that were made by the respondent, wherein he basically admitted that he had shot her. There were statements made basically that he was intoxicated at the time. He had blown .159. He had shot her 4 times. He unloaded on the pistol, which was a 5-chamber pistol. So he emptied the rounds out of the pistol when he killed her. I believe the court has more than sufficient evidence in front of it in order to make the determination by a preponderance without conducting the evidentiary hearing. The 2 pieces of information, Judge, which I couldn't get to you, were one of his interview and the second of the 911 dispatch call, both of which, after filing my petition or my subsequent petition, I did get a hold of. What I was informed by the court staff was that due to IT restrictions, they don't like it when out of network devices are connected into your network. And so they didn't want me to supply the USB because it wouldn't plug in. That's what I was informed. In 20 years of practicing law, I've learned not to argue with court clerks. You just say thank you and move on down the line. And that's kind of what we did. But I do have both of those here with me today, including Mr. Maples' interview with the PD from the night of, as well as his 911 call. In both cases, he makes several admissions that he did kill Kathy Maples. And so I don't believe the court, under either the Hadley or the Mike's opinion, requires it to conduct a full-blown evidentiary hearing. I think the court can look at the various pieces of evidence that it has in front of us and make that determination without conducting it. The second reason, Judge, why it made me, which is actually the first issue in my brief, relates to this was filed basically in response to the objection that Mr. Maples filed. And Mr. Maples filed an objection that basically tries to say, well, he was mentally ill at the time of the killing. I would note that in the police report, he tends to make some passive suggestion that she had attacked him, so he shot her 4 times. He makes a suggestion, and the evidence suggests that he was actually intoxicated that night, having blown .156, I think, which was almost twice the legal limit. So the first time this issue appears to came up was in his pleading that he filed. But I've given the court, again, both the Hadley opinion as well as the Mike's opinion and as well as the Henry Nail estate opinion. And in those cases, the Court of Appeals said on 2 different occasions that we don't need a first-degree or second-degree murder for the court to basically apply the statute. In the Haley opinion, the defendant in that case pled guilty to involuntary manslaughter and second-degree arson. And then in the Mike's opinion, the respondent was actually charged and pled guilty but mentally ill. And so he actually pled that he was guilty but suffered from a mental illness. And in both of those cases, the probate courts basically said that there's sufficient information to find by a preponderance of the evidence that the respondent in those cases had committed one of those offenses, and that he was not going to be allowed to inherit. And so both of those opinions appear to be directly on point with exactly what Mr. Maples is attempting to argue in this case. And the Mike's opinion appears to be directly on point, which is he's trying to say he has a mental illness or suffered some type of mental illness. And the Court of Appeals in that case said, we don't particularly care. And in both cases, Judge, they tend to go back to saying either A, subsection 6 applied, and or, Judge, even if that were not the case, they went back to subsection 5, which is basically the policy which our legislature has outlined for us, which says a killer's or felon's wrongful acquisition of property or interest, which isn't covered by this section, must be treated in accordance with the principles that a killer or felon, a killer or felon cannot profit from his or her wrong. And in both of those cases, the Court of Appeals have came down and said, even if subsection 6 doesn't apply or we don't get to this, subsection 5 is the fallback, and we do not allow killers to inherit from those that they kill. And again, Judge, I go back to the Hadley opinion as well as the Mike's opinion, and probably in more direct fashion, the Mike's opinion where the defendant pled guilty but mentally ill, and the Court of Appeals said, we don't particularly care if you are suffering from a mental illness, you are not going to be allowed to inherit. And so I guess to summarize, Judge, I don't think he submitted any form of a valid defense to anything which has been alleged. And then second of all, I don't think the court is necessarily required to conduct an evidentiary hearing, albeit we've got 4 witnesses here to potentially testify. I have the interview, Judge, which is probably 45 minutes long. And then I've got the 911 dispatch call as well as the dispatcher here, which is probably about another 10 minutes long. And so I can present the evidence if the court desires it. I am concerned again over res judicata and interfering with what the prosecution may have going on, but I don't think the court needs to conduct the hearing given the brief that I filed.
All right, we're going to go over to Mr. Stephen Maples for a moment. If you could, please unmute on your end.
Good afternoon, Judge.
Okay, I'm having a little trouble understanding you. It's a little muffled. So were you able to hear everything that Mr. Hamden presented just now in argument?
Yes, I could hear quite well. Thank you.
Good. All right. And I have received your objection and read it. Understanding that obviously you have some criminal proceedings pending, do you wish to make any statements today?
I'm concerned that I'm without benefit of counsel, Your Honor.
Okay, you've got to slow down for us. It's very muffled. So if you could just go really slow for me, please, that would help.
I'm concerned that I'm without benefit of counsel.
No, that's not helping. I don't need you to get closer. I just need you to go very slowly.
I have concerns about being present without benefit of counsel.
Thank you. Perfect. So unfortunately, this is not a criminal, well, fortunately, perhaps, it's not a criminal proceeding. So I cannot appoint an attorney for you. You would be welcome to retain your own attorney, which was communicated to you by our clerk's office. I know, because I have a copy of that in the file, and we'd be happy to accommodate that person. but you are not entitled to an attorney for this probate court proceeding.
Okay. The reason I wrote to you in the first place was because I had concerns about whether property of mine that would not necessarily be considered joint property might be taken. And it seems that might have been the case already. I'm not sure. A personal representative of mine with my power of attorney contacted the bank, who told him that the accounts there had already been closed, and he was there to inquire about my Social Security checks so that I might have those funds to retain counsel or our own psychiatrist. And I'd like to know if those accounts were closed by your order or by my daughter. And if so, what happened to the funds?
I think that does raise an interesting question, Mr. Hampton. Which pieces of property would be concerned specifically by your action?
It's a good question. Because I didn't write the statute. The statute basically indicates, Judge, that in the event that the decedent died intestate, the decedent's intestate estate passes as if the killer or felon disclaimed his or her intestate share, which would basically be indicating any property which was held in this case by Kathy Maples, solely by Kathy Maples, that it would be indicating that he would basically disclaim any interest he has in that. It then goes on under subsection 2A to say that it has the following effect. It revokes all of the following that are revocable: disposition or appointment of property made by the decedent to the killer or felon in a governing instrument. And it defines governing instrument as basically it uses the own term to describe a governing instrument. It uses governing instrument is a governing instrument. So it's a little off, but basically the way I am reading that statute is any governing instrument, which could be interpreted as life insurance, retirement account, or anything to which he is listed as a benefactor or a beneficiary of, that is a governing instrument which he would not be allowed to inherit from. Now, his Social Security checks, which he's getting, those are his. Those would not fall into Ms. Maples' estate. It wouldn't fall into any estate. If I were to pass away today, my wife's Social Security doesn't pass into my estate. That's her money, free and clear. Nobody's intending to touch Mr. Maples' Social Security or even retirement account that he may have individually or separately on his own. But anything to which he was a benefactor of, to which he was a beneficiary, he is not allowed to inherit. And anything that would fall through into the estate is basically, he is treated as though he has disclaimed that interest. The only other form when reviewing the statute that I can see that specifically makes reference is that with regard to real estate, Judge, to which the parties hold as joint tenants with full rights of survivorship, which in most cases would be, at least in this context, it would be as tenants by the entirety because they're married. And subsection B, 2B, goes on to say, in the event of a killing, the effect of the killing severs the interest of the decedent and killer or felon in property held by them at the time of the killing, abuse, neglect, or exploitation as joint tenants for the right of survivorship, and transfers that interest of the decedent and killer or felon into tenancy in common. So basically what it would do, Judge, is the third thing it would do is it would take joint real estate and basically that's being held as joint survivors and sever that into a tenancy in common. So he would still hold a 1/2 interest in any real estate. But the other 1/2 would flow down into the estate. And then once again, because it's flowing down into the estate, it's presumed that he's going to disclaim his interest in it and it would pass down to the 2 daughters. So that's how I read the statute. That's the effect on the 3 items of property. Subsection 2A also talks about his ability not to act as a PR or an executor. And it says it revokes any governing instrument conferring a general or power of attorney on him. or nominating him in any governing instrument as a fiduciary or representative. So he's not even allowed to serve as a PR in this estate under subsection 2A, subsection 3. But with regard to property, it has those 1, 2, 3 effects, which is 1, he's not allowed to inherit under any governing instrument. 2, he is treated as though he disclaimed any interest in the estate. And then 3, it severs the joint interest held in real property.
So if he has an account that he shared jointly that is receiving his Social Security, which I think is his concern that he's raised, how are we separating out what is his out of that, hypothetically, in the event that I agree with you 100% on the reading of the statute, and this is all established, that he is to essentially disclaim and have the effect of everything you just described? How do we separate out his portion of that bank account?
We could confer this with Mr. Maples however he would like. My client has begun the process, and I may need to get Ms. Williamson's input on this, but my client has begun the process of beginning to discover what assets may be out there. We are cognizant that there is a bank account, and we served the court's protective order on it in order to restrain assets. I don't think Ms. Williamson would have any objection, and I'm watching her, Ms. Williamson would have any objection to basically taking his Social Security portion and either forwarding that on to his defense counsel or forwarding it on to the jail so that he could handle it however he would like. But the estate has no ability to inherit off of his Social Security. That's his property, and as I read it under the statute.
Is this bank account that he's referring to a bank account that's held jointly, do you know?
I do not know the answer to that.
Mr. Maples, is the bank account you're talking about held jointly?
Yes. Yes, Your Honor.
Very well.
So we would need to coordinate with the bank in order to figure out how much his Social Security was in order to sever that portion off and move it over to a different account, either with his public defender or with the jail. And either one of those, I'm sure Ms. Williams is nodding a little bit more now. So we would have to figure out how to coordinate that. And I'm not opposed to it. So likewise, if he's got other retirement, Judge, if he's got a pension or something he's receiving, those assets belong to him. Those do not become part of the estate. So if he's got other assets to which he's receiving income, those belong to him.
Okay, Mr. Maples. So the way I see it, you will obviously have some, regardless of what happens here today, you will have some of your assets will be retained by you, even in the worst case scenario here, which would be half of any interest that you have in real estate, as well as whatever portion of those bank accounts can be established as yours. So there's also the argument by Mr. Hampton that I could make the decision on what he's asking me by simply looking at what he's presented, or we can have a hearing.
I would like to.
Go ahead.
I would like to raise 3 issues of fact, if I may. Kathy did not die intestate. We have had reciprocal wills since 1983. The most recent, I believe, was made by an attorney who created a living trust for our family. I don't remember his name, McFarland, something like that, and it was back in the 03-04 time frame. I don't know where the wills are right now.
Oh, I missed that last part.
I don't know where those wills are right now. I know we had copies of them in our home office. Second point of fact, I don't think I unloaded the gun. I think one of the police.
Okay, Mr. Maples, hang on before you go any further on those points. I just want to remind you that you do have felony charges pending against you, and anything that you talk about today will certainly be looked at by the prosecutor and the investigators that are handling that case. So,
are you advising me not to speak to factual matters at this point?
I'm not advising you of anything. I'm just reminding you of some of the
Sure.
circumstances around your case that could impact whether or not you want to make any statements to that effect. But before we get into that, my question to you is, do you have a preference on whether or not I make a decision based on looking at the police reports and the materials that Mr. Hamden has provided me, which would alleviate your opportunity or obligation to participate in a hearing? Or do you want to have the hearing and have the officers testify as to perhaps some of the contents of the report and their investigation?
As I told you in my letter, Your Honor, I don't think there is any necessity for having these people here testifying.
Do you have an objection to me reading the police reports instead of listening to their testimony?
None whatsoever.
Okay. So you would like me to look at the police reports and make a decision on Mr. Hamden's request?
You did receive my 7-page letter.
Yes.
Okay. Then I have no objection.
All right, very well.
If I could, Judge, one other matter. There were two items, Judge, which I referenced in my brief as I alluded to. My wife tells me I talk too much. She's probably right. There were two items I alluded to in my petition, specifically his interview with the sheriff department on the night of, as well as his 911 dispatch call. And I can handle that one of two ways. I can turn those files over to the court for Your Honor's review, or two, I can simply play them here on the record, understanding that the IT department's restrictions with regard to plugging in out-of-network systems. I'm open to either option.
Did you provide all of the materials that you provided to my office to Mr. Maples?
I can't, because they're metal and he's not allowed to receive metal. And so
What about the documents that?
all the paperwork, Judge, he got.
Okay.
The police reports he got. The medical examiner report he got. And then I think there was a third document I attached as well. He got all of my paper. It comes with no staples. It comes with no paper clips. It comes with nothing at all. But the two videos he does not have. And what it may make sense to do is to simply, so that he's not necessarily being prejudiced. He's actually, I think, looking at the documents there, Judge, in the Zoom room. He's got them.
Yes,
And
that's how big my stand
It's
is.
7 inch.
And so
Documents.
I could simply, Judge, just play those on the record, and then at the very least, he has an opportunity to review them along with the court, as opposed to them being reviewed on their own. But I'm open to either option.
Well, let's ask Mr. Maples. Mr. Maples, Mr. Hamden has the 911 dispatch call and the interview of the night of, it sounds like. You're not able to receive those because of your incarceration. Do you want to look at those on the record with me today, or do you want me to look at those without you, or not look at them at all? What is your preference?
Will I have the opportunity to make remarks about them?
You could, yes. We could watch the videos, and then I suppose I could allow you to make any remarks that you want to make. I would agree with you, though, as far as you needing counsel at that point.
I think that in the letter, the second letter that I sent to you, I think I addressed all of the concerns that I had about the reports that I had read. If this were the criminal proceeding, and these people were giving testimony at this point, I think there are some questions that I would want them to answer specifically, and that I would want to challenge. But I think I've given you as much information as makes sense under the circumstances. So I guess I will. I don't feel any need to participate in a rehearsal of these documents or the videos or audio tapes.
All right. Would you like to be present for the playing of the video and the audio?
Are we doing it now?
Well, potentially we could do that now. Yes?
As you wish.
All right. I'm going to take just a brief recess first so we can figure out the technology associated with that particular request.
I am working on it. And my wife is the IT guru in my house, not me. But I am working on it, Judge. And as your clerk may know, I'm logged in on Zoom right now also as a participant. I'm going to see if maybe I can play it, if it will play through the Zoom. If the court will allow me to simply share the audio playback and the video playback, and then I don't have to hook into your network. It's all being done through Zoom.
So I appreciate that. But I'm going to be honest, the more I consider Mr. Maples' position, his circumstances, and the fact that any funds that he could have used to pay for an attorney have been frozen by the protective order. I think we either have to figure out how much to release to him in his funds so that he can retain his own attorney, or I would have to look at appointing him an attorney, understanding that he may have to reimburse the court for that. I don't want him to.
Could I be provided with a transcript of the 911 call or the videotape interview in lieu of whatever this is?
I could do that. I've got a court reporter I could use, and I could just supplement my filing today with transcripts from the actual event and then serve him with those.
Let's go ahead and adjourn today's hearing to allow you to do that. I don't think you'll need to return all of your witnesses unless something changes, but Mr. Maples has agreed to allow me to look at those things. And it was his idea to do the transcript, which could be very useful. But I want him to have the opportunity to talk with an attorney. So I'm going to need you to figure out how much of those funds in that account. I mean, this is an interesting situation as far as. Okay, well, let me ask you this question. What is the amount in that fund, right, in that bank account right now?
I don't have the answer to that question. I'd have to talk to my client, and I'm not sure she has it either.
Ms. Williamson, do you know the answer to that question?
Yes, Judge, I actually found out today, but I do not know where the funds came from. I've only able to see the total in the account, so I don't know what's going in or what's going out. But the total is $49,000.
And I think it would be appropriate to allow him to use those, at least a portion of those funds, to secure private counsel.
Judge,
If
I think the issue with that. Go ahead, Susan. I don't want to interrupt.
I'm sorry, I wanted to know if it would be helpful if we could get the statements from the bank that could show us what was coming in for Stefan and make sure that his VA and his Social Security and everything was allocated to him. I don't want to take any of his funds.
I think probably what would need to happen is we would need to figure out the amount which he would have received after the passing of his wife, or after the killing of his wife, and that would be the portion which he would be entitled to, Judge. The rest of it, while this petition is pending, otherwise, Judge, what ends up happening is if the court ultimately grants the petition, he's going to end up owing money back to the estate, which he should never have received. And so I think the way to handle it would be to figure out what that amount is, and then we just simply find a way to transfer that over to him one way or another.
Well, that assumes that you'll be victorious in your action. And I think that making that assumption at this juncture would be somewhat prejudicial to Mr. Maples. And I also think that depriving him of his opportunity to secure private counsel by freezing those funds puts him at a significant enough disadvantage that it's worth stopping today's proceedings to allow him to look at that, frankly. So, Mr. Maples, the long and the short of it is, I'm going to find a different date for this hearing and allow you access to those funds to secure an attorney for purposes of reviewing what's been filed here so far and appearing as necessary.
How much of that is to be released, Judge? Because a portion of that under the statute would have belonged to Ms. Maples and ultimately the estate.
Agreed. So what I think we should do is, Mr. Maples, you're going to have to probably find an attorney and then send some information along to Mr. Hamden and to myself, letting us know who that attorney is and what that retainer looks like, so that we can set a quick hearing on it to determine whether or not that's going to be appropriate. And that way you'll at least have the opportunity to object, Mr. Hamden, or to look at that issue and look at the funds and resources available in the meantime that you may agree with. But the long and the short of it is, I think he has to have the opportunity to retain his own counsel. We can't just assume that none of it's going to be his and require him to move forward on his own.
And then the court also wants transcripts from the 2 videos so that I can supply those. Does the court want the actual videos themselves, or does the court just want me to provide it with the transcripts?
Well, I think that may be impacted by whoever Mr. Maples locates to assist him. Whatever that attorney thinks, frankly, if they just want to, if he or she just wants to watch the video or wants to have that expense also taken on by, I'm sure, the estate effectively.
Okay.
All right, Mr. Maples, how much time do you think you're going to need to retain or locate an attorney to retain?
I have no way to estimate that, Your Honor. I do not even have access to directory information in this place. I don't know how to find an attorney blindly. The only ones that I have access to are the public defender's office, who has stated that they have no expertise in probate matters and cannot assist me. I have given a gentleman a power of attorney in authorizing him to act on my behalf with matters regarding the bank and Social Security, and I will try to get him involved in locating an attorney for me in this case. And so I'm not able to answer that qualitatively.
All right, well, how about we start with 30 days? The next available time I have to come back on this matter is August 9th anyway, August 9th at 10. Mr. Hamden, if you could look, or I have August 28th all day. But as I said, I don't know that we'll necessarily need all of that time. But if I give you 30 days, Mr. Maples, to supply me in writing who you would like to retain and how much that would be. If you need extra time beyond that, and you can give me a good reason to extend that, I'd be happy to look at that, but I'm going to start with 30 days.
Thank you, Your Honor. I will do what I can in that amount of time. And if I fail to locate an attorney for any reason, I will contact you with that information also.
Very good. We'll send a copy of whatever we received to Mr. Hamden to make sure he's in the loop on that. Mr. Maples, what is the name of the person that you'll be relying on to help you with this?
Benjamin
Okay, Mr.
McWilliams.
Hammond, are you familiar with that person?
I am not.
All right, Mr. Maples, if you could have him contact Mr. Hamden, I think that could be useful.
I apologize to the court, but I didn't catch the return date for the hearing.
It would be August 9th at 10 or August 28th all day.
I'm sorry, what date are we back then?
Well, I'm waiting for Mr. Hamden to tell me if he's available August 9th at 10 or if he would prefer August 28th. Do you have a preference, Mr. Maples?
Your Honor, I'm at your disposal.
Thank you.
Is the court scheduling this for an evidentiary?
I think it would be best just to schedule it at this point for a preliminary hearing or like a pretrial, basically.
Okay, and then between now and then, I will turn the transcripts over and the court will have the information it needs. So the 9th would work, Judge.
All right, so we'll schedule this for August 9th at 10. And Mr. Maples, you'll have 30 days to get me the name of your attorney. Have Mr. McWilliams reach out to Mr. Hamden as well with the name of that person, so that if there's an agreement that could be made to allow that retainer to happen without my involvement, then we can expedite things that way. Otherwise, when I get that information, we'll try to get that circulated and set up a time to come back onto the record to determine whether or not it's appropriate to allow payment of funds for that retainer. Just so that Mr. Hamden would have an opportunity to object, but I think everyone understands pretty clearly at this point that you're going to be allowed access to those funds for purposes of retaining an attorney.
Thank you, Your Honor.
And then, Mr. Hamden, if you could go ahead and initiate the change in the interim, you could give me an order that to this effect that effectively there should be a new account set up for Mr. Maples to receive directly his funds that under any circumstances would already be his. You can use obviously Mr. McWilliams, who's been given the authority to handle those financial transactions, to assist in that process. Is that acceptable to you, Mr. Maples?
That's the best I could hope for under the circumstances, Your Honor. Thank you very much.
Welcome. All right, so I, at this point, would not be inclined to continue the subpoenas necessarily for all your witnesses, although I do want to thank you all for your time and making time for us today. And I think Mr. Hamden could just make that decision in the future if he needs you again.
Yeah, my intention, Judge, is to turn the transcripts over, and my understanding is that Mr. Maples has basically indicated he didn't want to go forward with the evidentiary hearing. He wanted the documents reviewed, so I'll submit transcripts to that effect.
We're gonna, I will hold all of that without reviewing that until he's had a chance to have an attorney also weigh in on that issue. But I do think that that's a good use of our time moving forward.